Good afternoon and welcome to this webinar. My name is Tanya. I'm the CEO of TOKISO, and I'm going to be addressing the question or the issue of POPIA in our dispute resolution processes. I am not going to be going through POPIA. I trust you're very familiar with it and all of that, with the content of what POPIA requires. So I'm really going to look specifically at our processes in ADR. I'm sure all of us are tired of being inundated, particularly in July, with all those dozens of emails asking us to opt into various groups, communication groups. So it's very front of mind, this topic, for all of us. Now, just a couple of things around the webinar. Please feel free to ask questions in the chat function. There is a Q&A section as well. Please put that forward. Colleen January-Wright, our Chief Relations Officer, is taking questions, and she will put those to me at the end of the process. Also, feel free to give comments on where you disagree with me, or you may agree or want to add to what I'm saying. This is novel for all of us. We all trying to work through this new piece of legislation, and I don't have all the answers, but I certainly have a lot of questions which we're trying to practically deal with on a day-to-day basis in our processes. So also just another comment is that we are recording the session, and it will be up on our webinar on our website during the course of tomorrow. For anyone that happens to miss it, please feel free to share it with others. And also, it's become quite common to my theme is in celebration of our beautiful country. I've used pictures taken by TOKISO staff of landscapes in our country. Today we are celebrating the Magaliesberg and some of the rock formations there, which are just absolutely magnificent. The last cold snap of our winter season. So they're very wintry pictures. So let me move straight into it. There's a delay in my presentation for some reason. There we go. Okay, so just I said I was going to touch on the detail of POPIA and what it says, but I thought I have to start with the purpose of POPIA, and that is obviously to protect personal information and to strike this balance between the right to privacy and the need for the free flow of information and the access to information, and also regulate how this personal information is processed or used by various parties. So it's been in the making. I think it was first enacted in 2013, with the final provisions coming into force in 1st July 2021. So it's been a long time coming, and a lot of people have been preparing it for many years, including TOKISO, by the way. We've already been putting in place the necessary requirements for the last couple of years and complying with it. So moving to the players, I think it's worth just noting this as well in terms of our discussion, is that there's three critical players. There's someone referred to, quite unfortunately, I think, as the data subject. It sounds so legalistic, but really the person whose information the action relates to. So your information, you become the data subject. The responsible party being the person who determines why and how to process that information. And this may include juristic persons, such as your profit companies, non-profit organizations, government, private companies, but also can include individuals. And then there's something called the operator, which sounds like something out of a movie, a person who processes personal information on behalf of the responsible party. Now, that could be an IT vendor or somebody like that. But certainly the ones I'm going to be speaking to specifically is your responsible party and your data subject. So moving on, Section 13, I think, is also very critical for our needs, is that personal information must be collected for a specific, explicitly defined and lawful purpose related to a functional activity of the responsible party. In other words, you can't randomly collect information. It has to be for explicit and defined lawful purpose. And that is a theme that runs through all our processes, that when we do collect information, it has to be specific to that particular process. It cannot be random information about a person. So very practically for us, we will see it as an attendance register, for example, can't collect information that is not relevant and specific to that specific process about those particular persons attending the process. And that's the kind of way we've actually looked at it from cradle to grave on how we process information on cases. And this section is quite crucial for that purpose. Just other relevant processes for our purpose is that that I've just noted down, and is that the legitimate grounds for collecting and using personal data collected in order to ensure the data is not used in ways that are unjustified adverse effect on the individuals concerned. So we can't collect data in a way that could actually adversely affect the individuals or the data subjects in the way we do that. Secondly, and related to that, is the lawful purpose of which data is being collected to ensure that the data shall not be further processed in any manner that is contrary to the purpose for the purpose for which the data was collected. In other words, and this is absolutely crucial in thinking through things as panelists and as parties, is that when we do receive information, this personal information about parties, about witnesses, etc., we can't use it beyond the process for which it was intended. And we have to ensure that the information is secured so it cannot be extended beyond that use for which it was intended. And then crucial to that 13.1, and this is just reconfirming that section, is that the extent to which information that is required for the purpose of intended and to ensure that they collect adequate and relevant information and prevent any excessive information collection. In other words, we don't collect extraneous information that's not relevant to the purpose of which we need it. So, for example, one is if you ask for the date of birth of a person on a attendance register, why would one do that? It wouldn't be relevant to our particular processes. Well, certainly not in most cases, or not in any case that I can think of. Interestingly, race and gender would be another example, which we'd have to justify why one would be asking for that information before we seek it out. Is it really relevant to the process in which we conduct it? Of course, the Act does provide that such information can be collected, for example, for purposes of one's BE or employment equity plan. Race and gender of a particular employee could actually be collected, needs to be collected for that purpose. So again, I'm sorry, I'm putting up these sections. I'm not going to read it. It's not my style, but just want to highlight a couple of specific sections or specific relevant areas of the Act for our purpose, that being section 11 and 12. That is very specifically related to a case which I'm going to be covering shortly as well. But section 11 basically says personal information can only be processed if, and I'm going to just read the relevant sections, not all of it, processing is necessary to carry out actions for the conclusion or performance of a contract to which the data subject is a party. So if the information is relevant for purposes of enforcing a contract, then it does become relevant and one can use it for that purpose. And second, section is 1C there, processing complies with any obligation imposed by law on the responsible party. And then processing protects the legitimate interests of the data subject, and processing is necessary for the proper performance of a public law duty by a public officer or pursuing the legitimate interests of the responsible party or a third party to whom the information is supplied. So there has to be a legitimate interest for using it. So there is very specific provision for when personal information may be processed. But it also says that a data subject the person whose information has been used, can object to the use of their information, but only in relation to F in the subsection 1. So where it protects the legitimate interests of a data subject, proper performance of a public law duty by a public body, or a legitimate interest of a responsible party or third party. So that's very important, that there can be an objection there. And then subsection 4 says, if a data subject has objected to the processing of personal information in terms of subsection 3, the responsible party may no longer process that personal information. So in other words, that implies that a data subject can in fact stop the use of their information in those certain circumstances for purposes of further processing of their personal information. So, Section 12, also very relevant for our purpose, is Section 12 provides that personal information is to be collected from the direct subject. So the data subject, rather than from a third party. That's always best. So going to ask for that information from the data subject is ideal, and obviously getting their permission for purposes of the use in which it's intended. But it's not necessarily comply with that provision. If the information is contained, it gives provision in Section 12 for that. But so specifically for our purpose, I want to just refer you to subsection 2D, where it says collection of the information from another source is necessary to comply with an obligation imposed by law, or for the conduct of proceedings in any court or tribunal that have commenced or are reasonably contemplated. So in other words, information can be collected about a data subject for that provision from a third party. So in my view, reading this, and it'll be interesting to see how courts interpret all of this, but certainly in my reading, referral forms can include information of the responding party, so long as it's not extraneous information that's completely not necessary, but also for purposes of a tribunal or court of law's interaction, for purpose of processing a case. Now, I think that I want to take you through a case. It's a very recent case. This judgment was handed down in June this year. I love the name, by the way, Divine Inspiration. It's not a name you're going to forget. So Divine Inspiration is a case really dealing with where a party has refused to provide information even after it's been subpoenaed, and used POPIA as a basis to refuse to provide that information. And this is the first of the court cases I've certainly seen. I haven't been able to find, or I have no other cases that have come before me from a court. I suspect these cases are being dealt with quite readily in the tribunals, and it hasn't just come through the jurisprudence course yet. But I think we're going to see a lot of jurisprudence in the near future coming through. But this is the first of it, and let me quickly take you through this case. So the applicant, being Divine Inspiration, was a respondent in the action for damages against the responding parties. There were three responding parties. Firstly, Gordon, who's the first respondent, and then there were two other respondents in this particular case, and they were the doctors. I think it was the general practitioner and a psychiatrist for Gordon. And interestingly, in this particular case is that the merits of the case were not in dispute. That was settled, but the quantum was still in dispute. And what happened is that the Divine Inspiration, being responding in the original in the action, had requested the medical records of the first respondents. And in fact, that was not forthcoming. The second and third respondents, being the doctors, did not make it available, refused to provide it. Gordon refused to give permission for it. And then what they did is, in terms of a uniform rule of the High Courts, Rule 38.1, they provided they brought a subpoena for purpose of making those records available. The second and third respondent again refused even to comply with the subpoena, and that led to the action, this particular application by Divine Inspiration trading before the High Court in the Western Cape. And it's interesting is it was opposed by Gordon. He opposed the matter. The doctors didn't oppose it. And just very briefly, the reasons given for opposing by Gordon, the first respondent, was that Section 14 of the NHA, that's the National Health Act, prohibited the disclosure of those documents. And relevant for our purpose, I'm not going to deal with the NHA defense, but specifically around Section 11.1 of POPIA was not applicable in these limited circumstances. They're saying, well, it's not relevant, and therefore he doesn't have to comply and provide this information. Interestingly, he argued that it wasn't relevant for purposes of this particular, to determine quantum. The court found, analysed this, and again, they found that Section 14 of the NHA did not prohibit these documents in these proceedings to be made available, but I'm not going to deal with that in detail. But specifically relating to POPIA, the court found that the Uniform Rule 38.1 constituted a law imposing the duty to do so on the respondents as responsible persons. Obviously, that meaning the 38.1, the issuing of the subpoena, effectively imposed the duty on the responsible persons, being the doctors, to make and the first respondent, to provide those particular medical records. I do want to take you back very quickly to remind you is section 1C. Is that the processing complies with an obligation imposed by law. So that's the interpreting provision that the court was looking at, the provision that the court interpreted, and said that it was imposed by law, and therefore the respondents had an obligation to deal with it. In addition to that, they also said that because in terms of item 3, the data subject could not object, because it's item C and not D to F of subsection 1. It could not, in fact, object to the provision or to the subpoena, and couldn't deny not providing that information or honouring the subpoena. So very, very interesting case. And then also they found that the records were in fact in question were relevant to the inquiry before the court. And in terms of quantum. So very interesting that that the courts have started grappling with this issue, and I think our tribunals are going to be, and even our private hearings, our disciplinary hearings, our private arbitrations, we're going to be dealing with a lot of objections to information being provided, and presiding officers are going to have to also determine on what basis information will be admissible before them. So it's definitely about, Colleen is going to put up, by the way, just in the chat group, Colleen will put this particular case make it available to you, so that you can read it at your own leisure. But it's definitely, if you're very interested in the subject, very, very well written, and I think a very well considered judgment. Okay, just getting to the practicalities, having dealt with the kind of framework of what we're dealing with on a day-to-day basis. Just around POPIA and COVID, definitely COVID impacts on our lives every day. I was in isolation for 10 days recently. Wasn't fun, as I think most of us have had to go through that at some time or another. I was directly exposed and therefore had to honour the isolation requirements. But I've just disclosed to you, and I've deliberately done it, that I've been exposed to COVID. I did not end up having it. But I found that it's become quite common that we readily disclose every person's COVID status in processes and out. And my view about this is we're going to have to start curtailing that practice that we've become so readily part of our day-to-day discussion, because it is medical information. So in my view on how looking at POPIA is that one would not be able to disclose things like your COVID status in a hearing unless it becomes relevant to that specific hearing. For example, if somebody's ill and they've in isolation, and they would have to disclose that there's an application for postponement, for example, for that reason. And there would have to be good reason, obviously, not to do it online, by the way. So those are the kind of debates we're going to be having coming up with regard to COVID. Documentation, just around, I put in section 19, that's around security of information. I think we are seeing more and more around the obligation, both because of COVID, but we have a lot of online processes, and I'm finding that more and more we're seeing documents being password protected, and I think that's going to become a bit more and more common as we deal with online processes, where it's to prevent the dissemination of information beyond the process and those that should be responsible for that information. And Section 19 of POPIA provides the obligation that we ensure that that information is secured for only purposes for which they intended. So that password protection is probably the way that we're going to see things going. So just be aware of that as parties with receiving that information during online processes, that responsible person responsibilities extends to, I think, to parties as well. You'll also see TOKISO arranges the online processes and is quite insistent around that unless parties agree otherwise, simply because by arranging online processes, you have access to people's personal information, and that includes witnesses' information. And that's why we collect that information for purposes of the processes, and we manage those processes very carefully so that personal information is not shared unnecessarily with outside parties or unnecessarily. Just another items around online processes, and we all know that online processes have become, over half our processes are online at the moment, and that's largely because of COVID. And I think potentially this may not even change because after COVID. But just a couple of things we've just practically and anecdotally can tell you about that we've seen where there have been breaches of POPIA and also just breaches of the nature of how processes should be conducted. Is firstly where processes are conducted from home or public spaces. We see parties joining from coffee shops. Even in parks, I've seen somebody join from a park. Sure, that's fine. But there is an obligation, just like you do with processes and holding a process in a confined room physically, one would also need to ensure that you are in a confined space virtually. And that's very important. So not only that you're in a confined space, but that you're alone, and those that are in the room are allowed to be privy to the information that you are responsible for and not make it available to those where it shouldn't be made available to extraneous parties. So just around that is, so seeing, having entertaining figures walking behind parties in rooms should not be happening. And I do think there's an obligation on panelists to call people out when that does happen. Secondly, computer access and passwords. We know that I'm sure those that have work computers at home do need to be very careful about not allowing others to use their personal computers, particularly if it does have confidential and personal information of data subjects on it. And platforms, this has been raised with me by everyone in TOKISO, because with managing processes, we see this happening quite often, where parties share their screen rather than a document. So instead of sharing a particular document, like I'm doing now, I'm sharing my presentation, they tend to share their screen, and then they start opening emails and other things, and we start seeing a lot of personal information, which is a complete breach of POPIA. So those sorts of things parties and panelists need to be aware of, and where it does happen, and mistakes do happen, that you immediately find a way to address it. Either redact that part of the recording if the hearing's been recorded, alternatively ask parties to please be aware or find some other way to address that breach immediately. Finally, witnesses and reps. I had this recently where you're in a hearing and you have a break, and the representative and the witnesses or one of the parties don't switch off their video or their sound, and we start hearing confidential discussions between the respective parties, or there's some breach of personal information in that regard. So just I think these are practical things that you probably need to be aware of in any event, but certainly even more so because of the POPIA Act. So just around what TOKISO is doing, just so you know that TOKISO a couple of years ago, I think it's 2018 or 2019, we became ISO accredited. By the South African Bureau of Standards, we basically have our 27001 certification for ISO compliance, which means we meet all international, very high standard of international requirements in terms of information technology, security of information, and our management, information security management systems meet high international standards when we deal with party and panelist information. So it's important to note that. So that's why we've had these in place for quite a while now in terms of managing information. By the way, we've had to do this because of the nature of our work. We've gone this way, but also because of our international clients have required it of us. So coming just to ask some of the steps we practically do is TOKISA won't ask for excessive information from parties in their referral, in their referral forms, on our online system, etc. And anyway, if we do receive information, we are required to comply with POPIA, but also in terms of our certification. At the moment, we're sending our notifications and outcomes simultaneously to parties to their respective emails, and therefore we're disclosing the respective emails to both parties. We don't believe this is a breach of POPIA because that information is in the public domain to both the parties in any event, but obviously parties must not forward it, and also if parties specifically ask us not to do that, we would not do that. But notifications and correspondence, it's important for our independents to send it simultaneously to parties, and that's why we think it's absolutely fine to do so and completely appropriate. I've already spoken to us arranging our online processes and why we do that. Parties and panelists must ensure that when conducting a process, it's in a private setting. I've spoken to that already. And what you disclose in hearings, be very, very careful. If you are recording a process and you are providing personal information about parties, be it emails, telephone numbers, putting up on screen documents, and that recording becomes available outside, that could be a breach of POPIA. So we think that be very cautious if you do that, and it places a greater incumbence on you to ensure that that information is securely kept should you retain this information beyond the hearing. TOKISA's attendance registers, like I said, our attendance registers actually have a POPIA provision on it, and have had, we've done that for a couple of years now, to allow us to use that information. It says, it gives us permission to use that information on the attendance register for purposes of processing and engaging on that case. Our invoices go to specific persons, and we've been quite cautious about what information we put on the invoices so not to breach POPIA. Because, for example, if you put a name of an employee that's been disciplined or a name of a party on that, that in itself may breach some confidentiality and some POPIA provisions. Recordings, like I said, we've often requested recordings or make those available to parties. Once we do make those available, that party becomes a responsible person in terms of the Act and needs to ensure that that information is used for the purpose in which it's intended, and not to disclose it beyond what's it's intended. And I personally think this is going to be a big headache for lawyers and for parties, is documents that have unnecessary information, such as email addresses, telephone numbers, and it's like those emails and we all receive it, evidence. You get those big fat files of evidence, and there's all those emails, and it's been copied to several other party people it's not relevant to the hearing that their email address is on it. I think that information may need to be redacted in order to comply with POPIA, because it's not relevant for the purpose of the hearing, and why is it there? And it's something to think about when you provide documents in future. And panelists as well, when you're dealing with those documents, obviously, if you do, just be aware of that information may be confidential and should not be extended beyond what's necessary. It should not be provided if it's not necessary. And finally, TOKISA does secure documents. We will secure documents for a period of 5 years in terms of our policies and procedures. If you send it to us, panelists or parties ask us to keep information, we shall do so for 5 years. Otherwise, we will return the information back to the parties, or we will destroy that information. So one of the three happens, we will do so, either keep it, destroy it or return it back to the parties to secure it. And if we do keep it for 5 years, we will honor all POPIA provisions and also obviously comply with our certification in terms of ISO. Moving promptly forward, just a couple of notes before I take questions that I think we're likely to see. I think we're going to be seeing POPIA as arguments in discovery of documents, in sharing of information going forward. It's going to become common dealings in our hearings on a day-to-day basis. I do think we're going to see an increase in legal action for breach of POPIA. It's a matter of time before those cases start coming through our high courts. Workplace dismissals for breach of POPIA. We've seen several of those already where information has been breached, particularly when you're in hearings or people walking in. Information on desks, documents on desks should not be readily available or visible to parties other than yourself. So definitely workplace dismissals, breach of POPIA, just because of the liability issues that employers can attract up to 10 million rand, and obviously the criminal aspect of it, that I think employers are going to be very, very hard, come down quite hard on employees if there is if there's heavy negligence around breach of POPIA provisions. And finally, we're going to see a lot of adjustments on how processes are conducted as jurisprudence comes through. We're thinking of how things are. We interpret the Act in a particular way as TKISA. We're trying to answer questions when we receive it, but we don't have all the answers. And we certainly be watching the case law quite carefully around this, particularly around guidance in particular hearings. So it's something where we do think there's going to be a lot of adaptation over the years as time goes by and cases come through the system. So on that note, I'm sure there's a lot of questions and comments, and I see a lot coming through. So first, I'm going to go straight to it. Colleen's put it up on a screen next to me, so if I look away, that's the reason why. What can I do if someone shares my personal details? In a disciplinary hearing, an employer shares my personal details as a witness or party to the process. I think you can object immediately to that and ask it to be removed. And the employer has an obligation to remove it immediately. I know you can say, well, the damage is already done. But I think what you can do is the employer will need to give you some certainty on how you prevent that happening in future. But I think we're going to see a lot of big learning curves in relation to this. But I also think it's for the presiding officer to make sure that that information is not shared and that information is protected, and call out the parties when there is a breach. Because in my view and my interpretation of the Act, and I'd like to hear what other panelists and other people think, I think you're a responsible party as a panelist, and therefore you have to ensure that information is used responsibly. Next question is, we share lots of information during an arbitration that includes personal but relevant information to the process. What happens to these documents once the process has concluded? Who's responsible for making sure the process and documents shared in a process are compliant? I think it's for all the parties to ensure. But first and foremost, the party that makes the bundle of documents to the party who provides the bundle of documents, that's the first port of call. You are the responsible party. If it's the employer's bundle, it's for them to ensure that all the information in that bundle is relevant for that particular case, and there's not irrelevant or excessive information of personal information in that bundle of documents. So they become responsible. But I think once it's made available to other parties, they ought to become responsible. But I think it should be incumbent on the party that makes it available. And I think this is where personally, I think this is where the greatest risk is around documents and information in documents. Could an employer have an employee consent to the employee's information being collected, or does it form part of the relationship? Well, I think it's accepted in the Act, interestingly, that employers do collect employees' personal information, their telephone numbers, their personal information, their address, etc. So there's acceptance that that's necessary for purposes of the employment relationship. However, it's incumbent on the employer to secure it and make sure it's not shared unnecessarily. So even things like the race of the employees or the gender of employees is required, although because for employment equity purposes. So there's a lot of information, and it's generally accepted the employer requires that information for the employment relationship. So it's not a breach to collect it, but it could be a breach on how it's maintained and secured. And that's where the obligations on the employer reside. Okay. Ingrid, would Palace be covered by Tukisa's professional insurance? Yes, I do think they are. So any action, if there is litigation of Tukisa, just so everyone who doesn't know this, Tukisa does have professional insurance for all its panelists, as long as the process is conducted under the auspices of Tukisa. We are covered up to 10 million Rand. Please, parties that are online, don't use this as a reason to try and sue us. I'm really just joking, but in the event that there's litigation against Tukisa that's valid, and there is actually action taken in a court of law against Tukisa, we do have professional insurance that covers it, and yes, it does extend to this particular issue, I would think. Zarina, there's been a question there from Zarina. If one accepts that a disciplinary inquiry is not a legal process, that Tukisa chairperson is a third party, is there an obligation of the chairperson to ensure that consent was given by the employee for this external chairperson to have? What do I do as a chairperson when an employee objects to special information as opposed to personal information is disclosed to the third person chairperson? Should I ask as a chairperson, ask to see the consent? Sure, it's a long comment. Should I, as a chairperson, ask to see the consent form of the employee? My personal view, okay, this is, and I'd love different views on this because I can only give you my personal view because it hasn't been tested in a court of law, is that by you being appointed as a chairperson of a disciplinary inquiry, and this is different to a statutory process, which we know, like Tukisa is an accredited private agency, so where we hold conduct under the Labour Relations Act. So if we held a case under the Labour Relations Act, we can accept that that's a tribunal and we cover it. But private processes, which this falls within the purview of, disciplinary inquiries, grievance hearings, etc., in my view, by stepping in, you are an extension of the employer, and you have an obligation to comply with the confidentiality of that information. You can have access to that information in that particular private setting. Although you are independent, you're playing an extended role of the employer having the right to discipline, etc. They basically outsource that to you. So I don't think that you need to have a consent form per se, but you do become a responsible party to hold that information and comply with POPIA in the way that you deal with it. And that when the matter is dispensed with, that you don't hold or disseminate that information beyond what is required. We actually encourage panelists to submit the documents to us to file or to return to the particular party or to destroy. We do a lot of shredding in our office once we scan in. So that's my personal view of it. I don't think we must create unnecessarily complicated steps in doing the job that we do, but just to be very, very mindful that we're dealing with personal information in our day-to-day business. So that's my response to private information in these private processes. Another question I've got is there's a question around CCMA awards being details on the front page of parties. That's been done for the last since CCMA has been around since 1996, so for 25 years. The structure of the award included the name of the parties, their telephone number, their email addresses, the representatives, etc. Now, my understanding is the CCMA has dispensed with that. So they're very alive to that information being available on those awards. I do think that there is 1 million or so awards in the system with all that information, and what's going to happen to that is the question. But going forward, I think the CCMA is alive to it as it has deleted that. So Tukisa's never had that information in its award. It's never made that in, because we've been, in terms of our ISO certification, we've been alive to that for several years now. This may not be employment related, but the companies that share our information with third parties, are they not in breach of POPIA? Definitely. I think they are, that it's just a matter of time before those court cases those court cases come through with the sharing of our personal information to those dreaded call centers that call us on a regular basis, offering us these great deals, etc. So yes, I do think it's a breach of POPIA, and the Act actually provides specifically for this particular sharing of our information, that there has to be an opt-out, but also that such sharing cannot happen without express permission. And on whether it's also should go to the regulatory body, I know there's been an opinion provided around WhatsApp sharing information with Facebook, etc., and whether that can be done with the consent of the individual or needs to actually go through the regulatory body for purposes of approval of that. And the regulatory body said it needs to come through them. So I do think that this is a space to watch, and I suspect the courts are going to interpret this quite restrictively. Another information is private information in RBO reports. Historically, the attendance register has been included in RBO reports. It's one thing to put those that attended in it, but to put telephone numbers, details, etc., I think that needs to be redacted out and on a separate attendance register that's only provided as and if required for particular reasons. But the RBO and other reports should not include in them individual contact details and personal information unless there's very specific reason for it. And then obviously it should be confidentially maintained. Another question is, what about court files and being able to draw files for any matters at court? Yeah, I think it's the POPIA actually provides provides for courts using information. I think it's let's just check it. Section 15. We've actually got the act here. Yes, it is section 15. I'm right. 15. Section 15(3)(c). It says that further processing of information can happen for the conduct of proceedings in any court or tribunal that have commenced or are reasonably contemplated. So the courts can hold on to information for purposes of their cases, as we saw in the case earlier. But in relation to court case, people going into courts, collecting information, it'll be interesting to see how courts deal with that, because there's normally huge amounts of personal information in those court files. And to what extent are courts or parties responsible to ensure that information that is unnecessary for processing that case is redacted out of those court files? So that's something to watch. I don't know the answer. Could you imagine logistically doing that? Oh, I wouldn't want to do that. So it is something to watch. And then finally, another question, which is a bit of an abstract question, which I think I'm going to end on, is what is the difference between confidentiality and POPIA? I think they're different concepts altogether. Confidentiality is about the confidentiality of a process, confidentiality of a space, confidentiality of information, but POPIA is about personal information. So they overlap to some extent, but I think they're different concepts altogether. Really, POPIA deals with how, like I said at the beginning, if we go back to the purpose of POPIA, is how information is disseminated, managed, processed, etc. So it extends beyond just simple confidentiality of general information, but deals specifically with your personal information. Okay, so on that note, thank you very much for your participation, your comments. I really think this, I know it's initially when we spoke about this topic, about bringing up this topic, we thought it might be a bit dry, but I think it's such a fascinating area, and it's going to be such a massive growth, a discussion point in our day-to-day lives when we go through processes, etc. But we need to be mindful of personal information as presiding officers, as parties in our day-to-day processes. And I trust this webinar has brought these front of mind. But thank you for joining me, and we'll see you next time.